The Constitution of India guarantees various rights to its citizens, including no discrimination on the account of religion, race, caste, or place of birth. So the Constitution establishes some of these rights, and we call them fundamental because as they are core values that the citizens of India through their Constitution express onto themselves. However, if you look at the background or the backdrop of why such a right does exist, in a very negative context, it's not very positive but negatively expressed, saying that you cannot be discriminated on the grounds of religion, caste, race, sex, place of birth. So you shall not be, the state ought not to be exercising some of these things, and they shall not be discriminating you. It is a kind of a protection against the negativity of the state. Now, you will meet, friends, the word discrimination here is quite important. It means that there shall not be any adverse action, distinction shall be made. So, anyone who uses religion, race, caste, sex, or place of birth as a favor to, or as something to give something more to one religion over the other, trying to give something more to one race over the other, that is something that will amount to an infringement of Article 15. So it clearly says that there is a prohibition against the activities of the state, and the state shall not discriminate religions. They shall not discriminate race, caste, sexes. Sexes would be male or female, or right, I said in the in the Navjot Singh Johar case, it could be the LGBT community as well, because LGBT community are looking at their own sexual orientation as a consensual adult relationship. So that kind of a discrimination on the ground of sex is something that the Supreme Court in 2018 said violates law of equality. See, sometimes when you talk about this few aspects of say place of birth. Now, place of birth in India, because see, in India we have it's such a huge country, and there can be we have, see, let's just look at India, which has 22 constitutionally recognized languages. But apart from those constitutionally recognized languages, these 22 are basically only for the way the central employment examinations are conducted, or in the way the central government ought to actually give or notify legislations in certain kind of languages. They're only to that extent they're 22. However, in India there are more than 1,500 languages that are spoken of, apart from Hindi or English, which is the main language that is generally spoken about. For example, Hindi, it is said that it is spoken by nearly 44% of the Indian population. It's probably a majority language in that sense. However, because of the kind of diversity that we have in this country, now please note, we have diversity of languages, we have diversity of culture, we have diversity of cuisines, we have diversity of religion. We have so many diversities that exist in this country, and many of these diversities are divided in different kinds of states. So your place of birth can actually determine what language you speak, what culture you are, to a larger extent what is the kind of activities you are going to actually undertake. And hence, any discrimination on the ground of place of birth is not acceptable under the Indian Constitution premise. So I think place of birth shall not be the source of any kind of governmental disparity, any kind of governmental distinction, or any kind of government favors. This is what is the rule that is being laid down under Article 15 of the Constitution. We will notice that all societies have divisions. Divisions, as I told you, may be on social basis. Of course, there are divisions based on educational basis, and there are divisions based on the economic basis. Education basis, literates between illiterates, highly educated versus basically educated individuals. So I think the class of divide does exist in society. There can be social divides, there can be educational divides, there can be economic divides. The point is very clear that such kind of divides, though they exist in all forms and kinds of societies, including or more so in India, because of the vastness of the country and the different geography or culture that exists in India, the state shall not discriminate. That is the rule, and any kind of discrimination is unacceptable and violates the rule of equality as later in 14 and 15 of the Constitution. In India, there are many stories, and the stories go on to say that, only certain caste of women are allowed to draw water from a particular kind of well. There were two wells in many villages, one for the upper caste, one for the lower caste. What is a upper caste, what is a lower caste? The Harijans or the Dalits were called as the lower caste, and other castes were given the upper caste status. Generally, most of the caste discrimination in India existed based on what and who was in control of land and who were the working class. So the working class were often exploited by the landlords or those who were able to occupy that land. Now, please note, while this existed in so many other countries, which has resulted in a lot of political revolutions across the world, including communism, gave rise to empowering the working class. I think in India, what we realize is that it is very clear that such kind of treatment is unacceptable and no longer tolerable in a given society. Also, you will notice that religion can be the basis of discrimination often. For example, temples may want to discriminate at times. But again, you should notice that there is a distinction between public and private temples. Private temples can have certain kind of restrictions which are reasonable as per public policy, but they should not discriminate among the class of religion, class of religious faith. So that is a kind of a common basis for how the state must administer as well. Yes, I think what does Article 15 do? It protects the rights and interests of citizens. It also protects the right to religion in one sense, the right of belief, right of language, right of culture. You are free to exercise all these rights without the fear of the state, which will probably discriminate you or probably treat you unfairly just because you have decided to practice your religion, your faith, your language, your belief. So you should not have the fear. So the positive connotation of Article 15 is that while it says state shall not discriminate, the positive right that has been attempted to guarantee to the citizen is the right of religion, belief, language, and culture, and so on and so forth. There could be many aspects in terms of the discrimination that is required. So that is the positive right that gets to be protected over here. Now, one thing that we should understand, while we all know what religion actually means in this country, many of us may not know the distinction between race and caste. They're not necessarily one and the same. Now, race is actually kind of an ethnic origin, and it could be ethnic origin within a community of religion. It could be an ethnic origin within a caste itself. So there are so many races in India. If you compare mainland India to what is there with people from the northeast, sometimes we use the term race in those circumstances. Caste, of course, there are upper caste, lower caste, we have scheduled tribes, we have so many other caste systems in India. Every religion has two kinds of caste. In Christians, there are Catholics, Protestants. So these are castes that generally are there. Sex, again, you will look at discrimination for transgenders, for example. Right? That is also kind of a challenge, and that is also kind of a discrimination that can actually arise. So, of course, we are talking of different classes over here of people. Say one class of people in one religion as against another class of people in another religion. Advantages that are distributed by the state have to be given equally, and any kind of discrimination will amount to breach of the same. Right? So that is something that we have to appreciate and understand in terms of what this means. Now, of course, where discrimination is not permitted, this is very important. As I told you, it's not that in the entire country there won't be the practice of discrimination. Discrimination may exist in private places. For example, in my house, I may not want a particular religion or religious people to actually enter into. Do I have the right to privacy? Maybe yes. But discrimination shall not be practiced by the state or by the government, and it shall not be practiced in public places. That is the rule over here. For example, what is a public place? A shop could be a public place, a restaurant could be a public place, a cinema hall can be a public place, a well with water where people wish to access it because it is not a private well, it is a public well, and public well are for everyone's use, or a lake or a pond. These are places where no kind of discrimination can exist because these are actually constitutionally protected public spaces where every person in India, irrespective of his religion, race, caste, sex, or place of birth, must have access or equal access to. So it could be a bathing ghat, it could be roads, it could be trains. Wherever the state has given certain privileges and funds, discrimination shall not be practiced, and there is a very clear prohibition of the same. So please note, while the state shall not discriminate, people who are licensed by the state or who are given the privileges by the state also have a duty not to exercise these kinds and forms of discrimination, right? So that is how the basis of rule of law exists. However, let's understand that while this is the rule, there are obviously exceptions to this rule. The Constitution itself provides for certain exceptions, and one of those very strong exceptions are in favor of women and children. Now, women and children are not necessarily equals. So, while we say the rule of equality says the like should be treated alike, women and children are not included in the likes. They are unlikely, different individuals, or they are alikes. Women, particularly in terms of their vulnerability to social violence, their exposure to certain kinds of social stigmas and discrimination that existed in the Indian society. So, can the state make special protection for women and children? Now, please note, women could be in terms of a sex, children could be also in terms of the individuals in a given society. So, suppose the state wants to make certain kinds of reservation for women in parliament. Will it be permitted? Will it affect Article 15? The answer is no. Can certain reservation for women in the local panchayats be made? Will it attack Section 15? The answer is no. So reservation for women and children, for example, in bus or public transport, if you're going, certain seats are reserved for women. Now, this is essential, but one is to justify its essentiality in terms of public policy of the land. But that public policy itself was reflected in the Constitution, saying any kind of special protection to women and children shall not attract the rule of non-discrimination, and such kinds of state legislations that protect women and children are actually permitted. Second, any kind of provision which is supposed to be special provision, which has to be justified as special provision under Article 15, can be made for socially and educationally backward classes of citizens. Now, socially and educationally, social and education. So, primarily the test is being socially backward plus educationally backward for the advancement of such kinds of citizens and community. Can the state make any special provision? The answer is also yes. And hence, you will notice that there can be reservation of seats in public educational institutions on the grounds of socially and economically backward sections of the community. Similarly, in the socially and in socially backward sections of the community, can we include scheduled castes and scheduled tribes in terms of making certain kinds of reservations for scheduled tribes and scheduled castes in educational institutions so as to empower them, especially in those kinds of educational institutions that are aided institutions, that are government funded institutions. But please note, this exclude minority institutions. So minority institutions are protected against these kinds of provisions. However, all other institutions may be subject to the aspect of reservation, because that is something as an exception to equality, and that is something that is provided in the Constitution as well. Finally, I think very importantly, we brought in an amendment to the Constitution called the 103 Amendment, 103rd Amendment as it is called in 2019, and we created another class of individuals that have to be given special protection, and that is the economically weaker sections of the community. We call this EWS community. Can the reservation be provided based on not only social and educational backwardness? Can reservation in public employment, in institutions of government funding be provided on the basis of your backwardness in terms of economic capacity or economically weaker sections of the community? So the 103rd Amendment talks about reservation based on a 10% limit, and that is being provided. Now, you will notice that what is an economically weaker section of the community has to be probably decided by the law. Of course, there has to be an income limit. Anything above that may come under the creamy layer rule, which means that you're already past that economically weaker section of band, and you will not be probably entitled to the same. So, I think 103rd Amendment was challenged in the court, saying that can that be a new class of reservation that can be brought about as the economically weaker section of the community, but the court has agreed to the same. And please note, when you talk about economically weaker section of the community, the benefit of this 10% reservation is to be given to individuals or can be availed by individuals who are not covered by any of the existing schemes of reservation that is given for SC, ST, and OBCs. Now, what is the criteria for giving this economically weaker section of the community reservation? Because this is one of the latest amendments of the Constitution, I'll probably deal with it in these following matters. Persons whose annual gross income is below 8 lakh rupees can come under EWS. Annual gross income of less than 8 lakh rupees. This kind of 8 lakh rupees is an overall income. It is income from salary, agricultural business, profession, and it is for the financial year in which the applicant is making his application. So anyone who has a gross annual income of less than 8 lakh rupees comes under this scheme. Persons whose family owns or possesses any of the following assets are excluded from the EWS category. Who are they? Anyone who has an agricultural land of more than 5 acres, anyone who has a residential flat of more than 1,000 square feet, anyone who has a residential plot of more than 100 square yards in any municipal area, and any residential plot over 200 square meters in a notified municipal area are excluded from the EWS category. If property is held by a family in different locations of different places or cities, all of them will be clubbed together to hold the test of the economically weaker section of the community quota. Now, family for this purpose would include the person who seeks benefit of the reservation, his or her parents or siblings below the age of 18 years, as also his spouse or his children below the age of 18 years. So this is the combination of family that will be looking at the kind of income, property, assets, and so on. These are excluded from the EWS category. And the rest, anyone who has less than 8 lakh annual income can claim this kind of reservation. When it comes to reservation for the OBC community, the other backward classes, this is different from SC, ST. You will notice that the exception for reservation for OBC was brought about by the 93rd Amendment in 2005. And in order to give effect to this provision, please note, friends, the central government enacted what is known as the Central Educational Institution Reservation and Admission Act of 2006, providing a quota of nearly 27% for candidates belonging to the OBCs in all central higher educational institutions, including the IITs and the IIMs. The Supreme Court did uphold the validity of this act, and while the court said, fine, this 2006 act is fine, they said you must apply the creamy layer rule. Now, what is a creamy layer? Children who want to get into these higher education institutions and claim the 26% reservation in IITs, IIMs, and all central government institutions or universities under the OBC category, children of the following category will not get this quota. Who are they? First, children will be brought under what is known as the creamy layer rule if any of their parents uh, have hold constitutional posts like the president, the vice president, judges of Supreme Court, High Court, chairman and members of UPSC, state public service commissions, CEC, CAG, and so on and so forth. Children of Group A or Class 1 or Group B class of officers in all central and state civil services, all any kind of employees of PSUs, banks, insurance organizations, or even employees of universities. Also, in some kind of private employment, you will be brought under the creamy layer rule. If you are holding the rank of a colonel or above in the army, or equivalent positions in the navy and the air force, your children also will be brought under the creamy layer rule. Professionals like doctors, lawyers, engineers, artists, authors, consultants, and so on, they are also someone who are privileged and their economic status would have been elevated, and hence they are also brought under the creamy layer rule. People who are engaged in trade, business, and industry are also brought under the same. Anyone who holds an agricultural land above a certain kind of limit, or and kind of a vacant land or a building in certain urban areas. So suppose you hold certain kind of a land, then you are immediately brought under the creamy layer rule. Anyone who has a gross annual income of above 8 lakh rupees or possessing wealth of a similar kind of nature and character, this was also the basis on which a creamy layer rule can be actually established. Now, please note, the creamy layer rule was introduced in the year 1993. And we initially brought a ceiling of 1 lakh, and subsequently it was raised to 2.5 lakhs. Then it was raised to 4.5 lakhs in 2008, 6 lakhs in 2013, and finally 8 lakhs in 2017. So that is the annual gross income of 8 lakhs and above, for which you will be, treated as a creamy layer family, not entitled to the OBC reservation of 27%.